The Second Amendment, its past, present, and future. Today is what the American Constitution Society does well and best. I am Robert Rabin, a member of the board of the American Constitution Society. I want to thank Laura Schwartz for her incredible work in gathering two panels and a speaker, a lunch speaker for what will be an interesting and exciting and challenging day. The American Constitution Society. We connect law, cutting-edge analysis, and policy. ACS is a national network of lawyers, students, judges, and policymakers who know that law is a force to improve the lives of all Americans. We shape the debate, and we connect that debate to lawmakers and adjudicators. This year marks the 75th anniversary of United States v. Miller, in which the Supreme Court held Congress could prohibit possession of weapons not related to the preservation or efficiency of a well-regulated militia. In 2008, in Heller, then in 2010, in McDonald v. Chicago, the court held the Second Amendment provided an individual right to possess a firearm. Notwithstanding spasms of unrelenting violence, including the murder of children en masse, even bipartisan legislation to strengthen background checks fails in Congress. The right has and has invested in grassroots whose passion and connection to politics has proven unmatched. Those who favor sensible restrictions on guns, Everytown for Gun Safety, Brady, and other organizations, have manifested more support, but not enough to change the status quo. This morning, our panel of Second Amendment experts will consider if the court got it right in Heller, and our post-lunch panel will explore the legal and policy questions which surround the Second Amendment. Turning to today's first distinguished panel of men, we have a true expert to guide us, Professor Adam Winkler, UCLA professor of law and a leading scholar in the Second Amendment. His book, Gunfight, The Battle Over the Right to Bear Arms in America, is a must-read for any student of this important chapter in our nation's history. Professor Winkler, thank you so much for coming today.
Thank you very much. Thank you for the lovely introduction, and thank you all for coming and for ACS for organizing a great day of two panels, very terrific people, terrific panelists, and I'm honored to be with my co-panelists here on this. In 2008, as Mr. Radin mentioned, the Supreme Court ruled in a case called District of Columbia against Heller that the Second Amendment guaranteed an individual right to have firearms for personal protection. Although the Second Amendment was obviously part of the original set of amendments that were added to the Constitution in 1791, the Supreme Court had never issued an authoritative interpretation of the Second Amendment that said it protected an individual right to bear arms. There was the Miller case in 1939. That case was somewhat ambiguous in its phrasing, although it was interpreted by nearly all of the circuit courts to read the Second Amendment as protecting militias and not an individual right to bear arms. The text of the Second Amendment, as you may know, provides, quote, a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. And it's almost as if James Madison, the author of this provision, had just discovered this wonderful new thing, the comma, and wanted to put it in there as many times as possible. And since that time, generations of Americans have been confused about the Second Amendment. Its phrasing leads to an ambiguity that opens up for multiple interpretations. One prominent interpretation was that of the circuit courts after the Miller case, which said that the Second Amendment was designed to protect the well-regulated militia, as the Second Amendment refers to, and that it only was designed as a federalism measure, if you will. Like many of the provisions of the Bill of Rights, motivated by a desire to limit the federal government, that was granted so much extensive new power after the Articles of Confederation was replaced by the Constitution, that the Second Amendment was a way of combating Congress's or limiting Congress's extensive power over the militias. The original Constitution, as proposed to the states, included the militia clauses of Article 1, Section 8, which said, among other things, that Congress shall have the power to organize, arm, and discipline the militias. And according to the militia theory of the Second Amendment, the idea of the Second Amendment was merely to limit the extent of Congress's power to organize, arm, and discipline the militia. That they could organize, arm, and discipline, yes, but that they could not disband these militias because those well-regulated militias were necessary to the security of a free state, and so Congress could not disarm the citizenry by prohibiting, as a way of prohibiting the militias. The Supreme Court, I guess before I get to the Supreme Court, I should say that over the course of American history, people came to view the Second Amendment in somewhat different terms. At least a different view of the Second Amendment arose. And people started to argue early in the 1800s that the Second Amendment protected a right of individuals to have guns for personal protection, perhaps influenced by many state constitutional provisions. For all our focus on the Second Amendment, it's worth remembering that almost every state in the Union has a provision in its own state constitution protecting the right of people to keep and bear arms. Those provisions have been interpreted by the state courts since the first cases were in the 18 teens, and those cases have largely, though certainly not unanimously, held that those provisions protect an individual right to have guns for personal protection. And so you had these two competing views, a militia-based view of the Second Amendment and an individual rights-based view of the Second Amendment. The Supreme Court, for its part, never offered much clarity over the course of American history about the nature of this right. On occasion, the Supreme Court referred to the Second Amendment in a way that evokes an individual right to bear arms. So, for instance, in the Dred Scott case, Chief Justice Roger Taney, as explaining one of the reasons why African Americans could not be considered citizens, was he says because if they were considered citizens, they would have all of the rights guaranteed by the Bill of Rights, including the right to carry guns wherever they wanted, suggesting perhaps an individual rights view of the Second Amendment. The Miller case in 1939 seemed to suggest a different view of the Second Amendment, one revolving around state militias, preserving state militias, something that in the modern society, when we don't really have state militias in the same way that we once did, would no longer have much purchase and render the Second Amendment at least somewhat a constitutional irrelevancy. In 2008, the Supreme Court sided with the individual rights view in the Heller case. Justice Scalia's majority opinion for the court held that the Second Amendment was designed to protect access to guns for any lawful purpose, including personal protection in the home. Indeed, the court said that was the core purpose of the Second Amendment. At issue in that case was a Washington, D.C. law that banned civilians from possessing handguns, but also restricted their ability to use long guns. While they could have long guns, they had to be kept locked and disassembled, and you could only unlock them or assemble them for certain specified recreational purposes under the statutes of Washington, D.C., and that did not include self-defense, apparently. So there was a very restrictive law that really prohibited people from using any gun for self-defense. The Supreme Court in 2008 struck down that law, and the decision has been hailed as a triumph of originalism because the court used history and purported to find what the original meaning of the Second Amendment was. In 2010, the Supreme Court expanded on the Heller decision in a case called McDonald versus City of Chicago. That case held that the Second Amendment was equally applicable to state and local governments, that it was, in the language of constitutional law, incorporated to apply against the states through the 14th Amendment. As a result of the Heller and McDonald cases, now all jurisdictions in the United States must respect the individual right to bear arms. Now, this history and these decisions raise a host of interesting questions. What was the original purpose of the Second Amendment? What was it designed to accomplish? What did the framers think about gun control? Was Heller rightly decided? Was McDonald rightly decided? And what are the implications of these cases for gun control? And I'm happy and honored to have a distinguished panel to help us talk about these questions. To my left is Joe Blocker, who is one of the lawyers who worked on the Heller case when he was in private practice. He's currently now a professor at Duke Law School, and although only teaching for about 5 years or so, has become certainly one of the most original and creative and influential thinkers about the Second Amendment today. Mark Killenbeck, right next to Joe, is the Wiley H. Davis Distinguished Professor of Law at the University of Arkansas. His scholarship is focused on American constitutional history with a special focus on federal-state relations, and he is one of the leading experts on those areas in the country. And then finally, at the end of our panel, although certainly not least, if last in introduction, is Michael Waldman, who is the president of the Brennan Center for Justice. Mr. Waldman was a former director of speechwriting for President Clinton, where he wrote 2 inaugural addresses along with several State of the Union addresses. He has recently turned his scholarly focus and attention and published his most recent book on the Second Amendment, entitled The Second Amendment, A Biography, which was published just a few months ago to widespread acclaim. I apologize that we don't have Carol Birkin, who was supposed to be on our panel today, a historian from Baruch College. She unfortunately fell ill, leaving you with this hopelessly undiverse panel of white guys. But that wasn't our intent, but we did have some illness at the last minute. So let's start, if I can start with Professor Killenbeck. Can you provide us maybe with a bit of background on the drafting of the Second Amendment? What were the concerns expressed at the time that warranted adoption of that provision, and how did the Second Amendment address those concerns?
Thank you. I want to note right at the beginning that while I do spend large amounts of my time wading around in the late 18th and early 19th centuries, the Second Amendment has not been a particular interest, and so I felt sort of like a fraud until I remembered that some years ago, perhaps in response to flip remarks teaching constitutional law, a group of my students bought me a membership in the National Rifle Association, and so for 1 year I received a magazine, but more importantly, a plethora of truly intriguing catalogs, because they clearly sell their membership list, and it was really intriguing to see the things I could have bought. On the drafting of the amendment, I want to talk about a couple of choices that James Madison and his colleagues made as they went about this. The focus, clearly, if one looks at the history, was on the interplay between the fear of standing armies. If you look at the Constitution, you see other provisions in there basically saying the national government ought not have a standing army, cannot appropriate money for longer than a very brief period in support of armies or navies. And the idea that the militias, the state militias, which would consist of trained, armed, potentially armed citizens, would be a palladium of liberty in terms of their ability to respond to government tyranny. This came out of the English experience from the English Civil War period, et cetera, and truly there's an overwhelming in the record concern about this interplay between standing armies, which have great potential for tyranny, and militias, which are the people able to defend themselves. Now, with regard to the drafting choices, I take seriously, at least for the sake of argument, a statement that Justice Scalia, in conjunction with Brian Garner, made in his recent book, Reading Law, that we should be, quote, guided by the text and not by interpretations or ideas external to it. Now, there's some room for play in this statement, but let's look at the text. Adam's already given you the text of the Second Amendment, a well-regulated militia, comma, et cetera, et cetera. The important point in my survey of this, and something that I don't think that Justice Scalia accounts for, is there was a deliberate choice made in the light of various provisions that were on the books in other states. So, for example, The idea that state constitutions protected a right to bear arms and that state courts interpreted those state constitutions to have an individual component is a very intriguing idea until one looks with some degree of care at those state constitutional provisions. So the Pennsylvania Declaration of Rights in the first written constitution, that the people have a right to bear arms for the defense of themselves and the state. Vermont Constitution 1777, defense of themselves and the state. There are numerous state constitutional provisions during the 1770s, 80s, 90s, the period after ratification of the Second Amendment, that make deliberate choices to characterize the right to bear arms as a right that involves both defense of themselves and of the state. That is not the choice that was made by Madison in drafting. It was not the choice that was made by the individuals who ratified the Second Amendment. And I think that gets short shrift in the Heller opinion. Now, it's been suggested that the use of the term the people in the Second Amendment refers also to some collective right divorced from the idea that the reason why the people have arms is because of their potential service in the militia. If you look at the Bill of Rights, which is, I think, the best evidence of how the people in a provision in the Bill of Rights ought to be looked at. The people appears in the First Amendment, but it appears as a collective right, the right of the people peaceably to assemble. Now, I can have quite a nice assembly alone by myself in a room and, where I think great thoughts, but that's not a collective kind of thing. What about the Fourth Amendment? The people shall be secure in their persons, houses, papers, and effects. That sounds nicely collective, until you get to the operative clause, which is no warrant shall issue unless it describes the place, the person, or the things to be secured. And so while people is in there, again, there's a drafting choice. And that drafting choice in terms of individual rights is, dare I say, much more individual. Fifth Amendment, no person shall be held, nor shall any person suffer the loss of life, liberty, or property. Sixth Amendment, the accused, the witnesses against him, process in his favor or his defense. Again, there are drafting choices. Leaving aside the fun and games caused by the multiple clauses in the Second Amendment and leaving aside the incredible amount of time and energy, I suppose, fruitfully spent, some I think probably wasted on the significance of the commas, there are some significant drafting choices that were made by the people who wrote the Second Amendment that point toward a right that is associated with service in the militia, particularly when one puts that against the idea that militia service was basically something that was out there for all, not all individuals. We had some charming things about slaves and others, but most able-bodied men, unfortunately, I think I've known numerous bloodthirsty women who should have been in the militia, we're going to be serving in the state militias. And the Second Amendment is drafted in the light of that choice and in the light of a fear of standing armies and the militias as the palladium of liberty. Now, Justice Scalia explains this away by saying, well, there are other choices that were made by the states in terms of how they wrote their provisions, to which I respond, quoting Justice Scalia, we should be guided by the text and not by things external to it. And it's not as clear as I make it out. The one thing I learned rereading Heller and rereading all the bloody briefs is that Supreme Court shouldn't do history, and quite frankly, a number of the historians who did history for the court in those cases shouldn't do history. What about incorporation? McDonald. The idea here is that this is an individual right essential to our concept of ordered liberty. And, okay, we can go with that, except for one problem. And the problem is that if you look at the Second Amendment, it is unique in terms of the manner in which it was directed at the time it was drafted and ratified. It is a provision designed to protect state institutions, or the core for those state institutions, from federal interference. The other guarantees of individual rights in the Bill of Rights, the free speech guarantee, the free exercise guarantee, et cetera, are not couched in those terms. And so to say that we should now incorporate it and make it effective against the states when the states were themselves supposed to be the protectors of that right And the Second Amendment was put in there as a bulwark against the feds with regard to state rights, strikes me as a bit of a stretch. It strikes me as a bit of a stretch in particular when Justice Scalia and McDonald, in his separate opinion, talks about the subjective nature of the choices that Justice Stevens and Justice Breyer would like to make with regard to incorporation, and then refers to those things that he thinks clearly are not fundamental rights and or rights that are worthy of protection. And his laundry list includes abortion, homosexual sodomy, and truly interestingly, the exclusionary rule and the ability of parents to teach foreign languages, i.e. Meyer, one of the central cases in the history of American constitutional law. I think it becomes fairly clear when one lines these things up that there's a strong element of this is what I value, this is what the five of us think is valuable, as opposed to what the history might actually dictate. Now, having said that, I want to say two things. First, the Militia Clause in Article 1 speaks of the federal government as the place that might call up and might arm the militias. And that's an intriguing element of the Militia Clause that is not discussed in either Heller or McDonald in any great detail. Second, I have for 10 or 15 years been fixated on a phrase that Madison used in the Federalist Papers and used in his correspondence, that with texts that are indeterminate, texts that cannot give us complete meaning, we must liquidate and ascertain their meaning over time. So having given my declaration about the choices that were made when the Second Amendment was drafted, I concede that liquidating and ascertaining meaning over time is something that we should engage in, and that there might well be counter-arguments to what I think is a fairly strong argument to suggest that the majority opinion in Heller got it wrong.
And Mr. Waldman, I mean, you've done a lot of research on the original meaning of the Second Amendment for your book, The Second Amendment, A Biography. In your biography, sort of what is the story of the birth of the Second Amendment? And how did the phrasing of the Second Amendment make sense given the concerns of the time?
Well, first off, let me thank you and the American Constitution Society for having this conversation. This is a constitutional issue that is intensely felt by millions of Americans, and where most of the dialogue, most of the articulation has been over many years, over the past several decades, by folks who have the goal of looser gun laws. And it's important that all sides be engaged in this debate, and that progressives and people who think that there is a place within the Second Amendment for common sense gun laws be fully engaged, and I'm really appreciative to be a part of it. When it is Justice Scalia himself who said that the Heller opinion was the, quote, vindication of originalism. And he was very proud of it, and has continued to hold it up as the epitome of what searching for meaning in the text, or the original public understanding of the text, can mean. It's important, therefore, to understand, first of all, just to reinforce some of what the professor said, that the first half of the amendment was not, to the framers or their generation, throat clearing, but very much what they were focused on in their public debate about the Second Amendment. Those militias, we need to understand, were not like anything we have today. Every adult male, eventually every adult white male, was required to be in the militia their entire adult life, and they were required by law to own a gun and keep it at home and bring it in for the militia service. And there was a tremendous fear, as has been described, that the new central government, which emphatically in the Constitution thrust toward greater central authority, could crush those state militias. But it was a world of governmental compulsion, of a universal lifetime draft, that we would regard, and I suspect the people who are so gung-ho on the Second Amendment would also regard as utterly alien to the way we think of individual rights, or at least the role of government in society today. I was struck in looking at the history, the texts, the records of the founding and of the Second Amendment. First of all, how hard it can be to divine meaningfully original meaning. Jack Rakov, of course, in his book talks about this, that there were a lot of different perspectives, and that in fact the framers were often responding to what they regarded as a kind of noisy reaction from the public, and it's very difficult to actually pull one meaning out of that period. Having said that, and it's also noteworthy that when originalism was first put forward in the 1980s with such force by conservatives as the only legitimate way to understand the Constitution, starting in a very big way with the rise of the Federalist Society, Attorney General Ed Meese's speech to the American Bar Association, putting forward a jurisprudence of original intent as the only legit way to look at the Constitution. At that point, it was a lot harder to even pretend you were doing originalism. You kind of needed a library card to the University of Chicago History Library. Now it's all online. And the ability to go look at the original texts and the original history is available to all of us, and it leads to some surprises. Among the surprises is the extent to which the militias was the focus, but also the degree to which the militias were not like the National Guard today. They really were something that no longer exists, but also what some of the meanings were. The professor referred to the people as a phrase, for example. One place where gun rights advocates frequently go to pluck the Founding Fathers quotes that you can sometimes see, such as Patrick Henry saying, the great object is let every man be armed, is the ratification convention for the Constitution in Virginia. Well, that was transcribed, and it's all available online. And if you look at the use of the phrase, the people, by all the speakers on the day where they were debating the militias and the right to bear arms, every single use of the people, the phrase the people, meant the body politic, meant everybody, not as individuals. Except for once. James Madison used the phrase the people as a synonym for the militia, as to whether the militia or an army would be used to put down rebellion. It was really fascinating. Another place where you can find surprising meaning in the record is the Library of Congress last year put online something called the Founders Online. It was the papers, all the papers of the 6 most prominent founders. The phrase bear arms, which Justice Scalia goes great lengths in his opinion to pluck the words apart and examine them each separately, and says that, well, while bear arms may have had a military meaning principally, that's not necessarily what it meant. If you look at the papers of Washington, Adams, Jefferson, Franklin, Hamilton, and Madison, the phrase bear arms or bearing arms appears 153 times, except for the ones where they say, hey, did you see we have a Second Amendment? And it says this. Every single use of bear arms was military in those papers. So there's lessons to be learned from there. 2 things to say, though, fundamentally. One is that if you look at the time, there was an understanding that people had the right to defend themselves. Guns were abundant. People believed they had that right of self-defense from English common law, but it was not necessarily viewed as constitutional, and it emphatically went alongside an array of gun regulations and gun control and gun safety laws at the time. At the time of the framing, it was illegal to keep a loaded weapon in your home in Boston. There were all kinds of restrictions on who could own a gun. There were recalls and registries, and during the ratification, the state of Pennsylvania recalled all the weapons, the militia weapons in the state, for cleaning, supposedly. So they understood whatever it was they were doing to be coexistent with gun safety and gun control. Having said all that, if we're just looking at the original intent and the original meaning of the framers in their time, you can look at the Madison's notes from the Constitutional Convention, with scattered exceptions, the records of the ratification conventions to the Constitution, which were, much of the debate was about, gee, is there going to be a standing army? and the record of the U.S. Congress as it debated in public in the House of Representatives, the Second Amendment, and there was not a word about it protecting an individual right for hunting, for personal protection, or the other things we believe to be at issue here. It was entirely around the civic right of being able to bear arms in your state militia to protect against central government tyranny. So I think it's really important that we not fall in the trap. We have to be able and willing to understand the original meaning and make originalist arguments, but to understand that original moment teaches us much but cannot give us the answer because it is so emphatically different from today. The concerns of then are so different from the concerns today. The militia system that it was designed to protect vanished pretty quickly after they were done writing the Constitution. I'm asked, just did a month-and-a-half book tour on the book and, asked repeatedly, so what was it, a militia or individuals? And the answer is kind of it was both and it was neither. It was an individual right, but the right to fulfill your duty, your civic and public duty to serve in the militia. Our questions to the framers would make no sense, just like their answers in many ways make no sense. So we have to draw what we can draw from the original meaning, but understand that it is only, as Justice Breyer said in his dissent, the beginning, not the end of the analysis.
Professor Blocker, many in the gun rights community especially argue that the First Amendment should be a guide to how we might interpret the Second Amendment. We've already mentioned this a little bit, and Professor Killenbeck mentions how the First Amendment uses the word the people. Is the First Amendment a good guide for interpretation of the Second Amendment?
I think in some respects, yes. I think that any guide can be a good guide, especially given that Heller and McDonald don't give us a whole lot of guidance in terms of what the standard of review might be for reviewing Second Amendment claims. The court articulates this kind of categorical approach. Some things are totally in the Second Amendment, some things are totally out, but it's a really sort of shallow, theorized part of the opinion, and I think it's been rightly criticized as such. The First Amendment, it's a neighbor. It might be some use, but then the Third Amendment is the neighbor on the other side, and that's doesn't get litigated a whole lot. That's the one about quartering troops in the home. You guys may remember from con law. I think that there are some tests from the First Amendment which may be useful to fleshing out what the Second Amendment gives us. One of the things that we get from First Amendment doctrine is that what are referred to as a core interests of speech, things usually considered political speech, political dissent. Those are subject to maybe heightened protection, whereas more peripheral things, commercial speech under court's current doctrine, get a little less protection. You might say the same thing about gun rights. Heller does helpfully identify for us what it considers to be the core of the Second Amendment, which is self-defense. In Heller and McDonald, the court uses the word core and central components to locate those as kind of the center of the Second Amendment universe. It says that those self-defense interests are most acute in the home. So you might think that a law which prohibited a person from having any kind of self-defense appropriate gun in the home probably going to be struck down under the Second Amendment, just as a First Amendment law would that prohibited core political speech. Having said that, free speech rights, despite their sort of hallowed position in our constitutional system, are not free from regulation. Free speech, even political speech, is subject to a variety of forms of regulation, which might have useful analogs in the Second Amendment context. One that you might think of, you may remember from con law, is time, place, and manner restrictions. Right? Even if you're speaking on a political topic, you may be required to get a permit if you're going to have a parade, or those are things that one might analogize to getting licenses to carry guns in public, for example. The First Amendment sort of carves out certain kinds of undoubted speech in the sort of common meaning of the word. Things like libel, obscenity get almost no constitutional protection, and one might analogize those to what Heller says about dangerous and unusual weapons, which is that those are uncovered by the Second Amendment. So I think there are some analogies to draw there, and courts have drawn those analogies. They've done it for 200 years now, connected the First and the Second Amendments. Heller itself refers to obscenity and libel and various other ways in which the First and Second Amendments might be connected. I think it's also true although the court's recent doctrine in First Amendment cases, especially Stevens and Brown versus Entertainment Merchants Association, have tried to sort of recast First Amendment doctrine as not involving interest balancing. They've tried to describe it as the sort of historical, categorical kind of approach. But I think it's more honest to say that at least before 2010 or so, First Amendment doctrine has really shot through in many cases with interest balancing. That is, you consider the government's interest in regulating certain kinds of speech, whether it's child pornography or something else. If there's a very strong interest, if there's serious harms at issue, then the government tends to get a little more leeway. And you might say the same thing about guns. And guns, of course, raise certain kinds of harms that speech rarely does. You have 30,000 people a year dying as a result of guns, about half of those suicides. You can imagine the government interest could be quite strong there. And so even if you're drawing the First and Second Amendment analogies, I think it doesn't immunize guns from regulation.
And Professor Killenbeck, I want to know, I'm curious what you think about the idea that the Second Amendment protects a right of insurrection. So one might take the idea that, okay, that perhaps there's not a lot of rhetoric in the founding era about using a firearm to defend your home against a criminal, the kind of quintessential idea of self-defense that we have today. But nonetheless, many in the gun rights community believe we should be very skeptical of any kind of gun control because one of the purposes of the Second Amendment, they claim, is to preserve a right of Americans to revolt against tyranny. That the founding generation, they were armed revolutionaries. They took up arms against a tyrannical government that they thought was violating their liberties. Can you talk a little bit about this insurrectionist view of the Second Amendment, whether it makes sense to think of a right of insurrection within the context of the Constitution and the Second Amendment?
Well, it's a compelling thing to think about. Pauline Meyer did some great work on this. In terms of the unruly Americans and the whole origin of the nation as a movement toward insurrection, toward revolt, fueled by the ability of individuals to band together and in some instances to be armed to do it. And I think that one person's insurrection is another person's terrible, illegal mob violence. So there's a subjective dimension here. The thing that's intriguing about that is that while the formal militias are no longer what they were, we have all sorts of other militias out there lurking in the woods. And so one of my students has given me a photocopy of the handbook for the Washington County Militia. The University of Arkansas is in Washington County, Arkansas. There's a militia movement out there, and that militia movement might be one that we could associate with insurrection, and their ability to be well armed is intriguing, particularly if one thinks in terms of the difference between the kinds of firearms that were running around in the late 18th century, the black powder single shot, and what was used with the armies, and exactly the same thing, muskets and long guns, versus what is routinely used by the armies of today, which are multi-shot, high-powered rifles. Is our ability to restrict the possession and use of those undermined by a militia-related theory of the Second Amendment, given the technological changes? And so the insurrection militia question poses all sorts of intriguing questions for what is really the ultimate issue. Everything I said about the validity of Heller and McDonald is largely beside the point, because each opinion concedes that there can be regulation, and the difficulty you get into then is to figure out what are the parameters of that regulation. What is the standard of review? This is what you talked about going to be. And within that, the First Amendment, I want to just quickly follow up. When you teach First Amendment law, theoretically the free speech right is a fundamental right. Theoretically, all of you who've endured constitutional law know, fundamental right, strict scrutiny, compelling interest, narrowly tailored. When you go into First Amendment free speech law, you don't find that test very often. The time, place, and manner test from Ward versus Rock against racism says if it's a content-neutral regulation, we aren't using traditional strict scrutiny. We're using something less. And so there are a bunch of interesting parallels that come in there, because at the end of the day, so long as the assumptions of Heller and McDonald are on the books, the important thing becomes, how will we test an individual attempt by the states to regulate?
and that's where the fun is now. Right, and it's worth emphasizing, I think, that idea that something can be a fundamental right and still be subject to regulation. There's this idea, and I was guilty of promoting it in my own constitutional law class for many years because the Supreme Court has said it so many times, fundamental rights trigger strict scrutiny. It's just not empirically true that that's the doctrine. The court has found that basically all of the Bill of Rights provisions, with a couple of very small exceptions, are fundamental rights and thus apply to the states through the 14th Amendment, but yet there's no strict scrutiny under the 4th Amendment. There's no strict scrutiny under most of the provisions of the 5th Amendment. There's no strict scrutiny under the 6th Amendment, 7th Amendment, 8th Amendment. Strict scrutiny is a doctrine that's limited to about 5 areas of law and really nowhere else. And so that idea that fundamental rights trigger strict scrutiny is one that's worth reconsidering. Mr. Waldman, I was wondering, you mentioned early on about some of the gun control laws of the founding era. And indeed, even though, as I mentioned earlier, the states have protected the right of people to keep and bear arms for personal protection in state constitutions for most of American history, states have also had a long history of gun control, have they not?
Yes, they have, and it is right that when you strip away the originalist pretensions of Heller and McDonald, the holdings in those cases were that there's an individual right to gun ownership for self-protection, especially in the home, but that right can be limited. And as Justice Scalia writes, all individual rights can be limited, and it is the challenge of determining the extent of that right, but also what are the permissible limits, is what we're all grappling with. Understanding that, and understanding that the militia system that was the obsession of the framers faded away pretty quickly, what is clear is that from that early time forward, in the United States, you always had both gun ownership and gun rights, and gun control and gun restrictions and gun safety laws. In the founding era, as I mentioned, and the historian Saul Cornell has led the effort to catalog many of these early statutes, which of course were local or state rather than the federal, because mostly because the federal government barely existed at that point. Everything from safety-related restrictions on, as I said, in Boston, you could not own have a loaded weapon in your home at the time of the framing. There were restrictions, all kinds of restrictions on the storage and use of gunpowder because it was dangerous. There were restrictions on who could, at that time, on who could own weapons. You had to, you could restrict people who were not loyal. Tories could not own weapons, that kind of thing. There were all kinds of restrictions and registrations and all other sorts of things about militia weapons, which again involved the vast bulk of the male population. Going forward, as the country grew more individualistic, as it moved west, and our understanding of this issue became more vested in the individual, there were also simultaneously gun laws, many of them dealing with carrying weapons, requiring that if you carried a weapon, it had to be in the open, or other things like that. And there was, over time, Professor Winkler, in his book, has a wonderful photograph, which, from the Wild West, from Dodge City, of the Main Street, the dusty Main Street in 1879 of Dodge City, the archetypal six-gun town, and the picture looks like a movie set. It's the saloons and the hitching posts and the dusty street, and it looks like you're on the Universal Studios backlot tour in the western part. And it says, "Welcome to Dodge City, firearms strictly prohibited." And even out in the Wild West, there was an understanding that, of course, people had guns and needed guns, but that there were appropriate restrictions. Then, and so much of the debate over this skips over the entire 20th century. As the country moved into cities, people came to realize that there was something very different about how guns functioned in crowded urban areas than had been the case even in the frontier or in the colonial period. And so you had, starting in the early 1900s, revolver acts and other local laws, many of which are still on the books, and many of which are the laws that are being challenged to this day by the Second Amendment Foundation, National Rifle Association, and others. You had those were not challenged or struck down or blocked by state or federal constitutional understanding of the right to bear arms. Then you had, as the country again grew and felt it needed a stronger central government, starting in the 1930s, federal gun laws. At that time, the fear that people had, there was a real fear of crime because of prohibition and its aftermath, and the newfangled technological breakthrough of the getaway car. So because of Bonnie and Clyde and John Dillinger and the other high-profile participants in the crime wave of that era, you had what was called the New Deal for Crime and the first federal gun laws, which, by the way, the NRA testified for. So again, throughout the country's history, there was an understanding that whatever the purview was of gun rights, that you could have gun laws and police power of the states, which people cared about very much throughout that period, and criminal laws, and that there was not necessarily any kind of an insuperable constitutional conflict between the two. The kind of libertarian, anti-government, individual rights-based approach to this is a relatively recent development as a central and legitimized constitutional argument. That really is only within the last 30 years or so.
One measure of that, too, that is interesting is to look at the NRA's signature publication, that magazine that Professor Killenbeck was getting when he was a member of the NRA, the American Rifleman. If you look back at the American Rifleman, which has been published for almost a century now, if you look back through issues in the 1940s and the 1950s and the 1960s, available at UCLA's library in big, thick books like this. I know I've spent many hours looking at them. You'll be amazed to find that for decades there was not a single mention of the Second Amendment in the NRA's signature publication. That changes sometime in the late 1960s. The Second Amendment starts to make an appearance there, and I can pretty much guarantee you if you pick up a copy of the American Rifleman published today, the Second Amendment will be featured on every other page, if not more so. And so it's a little sign of how the Second Amendment has become the central focus of the NRA in a way that it really was not as a matter of history. Professor Blocker, could you tell us a little bit about what Heller's impact has been on gun control? I think when Heller was first decided, there was a lot of celebration in the gun rights community that this would lead to a huge rollback on American gun control laws, and certainly some laws have been struck down, like Washington, D.C.'s ban on handguns and restriction on long guns. But what has the impact been so far?
This is a great question. I mean, I think if there's one thing about the history that I think is often misunderstood, it's what Michael Waldron was just describing, which is the coexistence of regulation with whatever understanding there was about an individual right, and this is a point that you make in your book very well. It's generally true of constitutional rights, as we were saying, that they are subject to regulation, even when they're fundamental rights. There's a great article out there called Fundamentally Wrong About Fundamental Rights, written by the distinguished scholar to my right, which makes that point at some length. With regard to the Second Amendment in particular, I think this is an issue that is missed both by people, or at least underappreciated both by people who criticize Heller and by people who celebrate it, which is the degree to which the court explicitly and specifically approves, or at least endorses as presumptively lawful, a potentially wide range of gun control. The Heller opinion, although it strikes down the D.C. A variety actually of D.C. gun control laws, goes on to say that it is perfectly constitutional, or at least presumptively lawful, for a state, locality, or federal government to ban possession by felons, by the mentally ill, to ban dangerous and unusual weapons, to ban weapons in sensitive places like government buildings and schools, to impose restrictions on the commercial sale of firearms. And then the court says, this is not an exhaustive list, we're just throwing out, here's 5, there may be more. Lower courts, courts of appeal, and district courts have taken that invitation and drawn analogies from those 5 categories to other ones, and I think sensibly so. Felons are one thing. What about people who've committed violent misdemeanors, or people who are under protective orders for domestic violence? Lower courts, considering those kind of challenges, have generally said, well, those aren't felons, but they're enough like felons that we're going to say laws denying them guns are constitutional. So the wording from Heller there, I think, has given a relatively big regulatory, or potentially big regulatory space When the court revisited this issue in McDonald, which is the case that extended the Second Amendment to local and state governments, the court again reiterated, pointed back to that passage, and then said, I think the exact phrase is something like, experimentation with reasonable gun regulation will continue under the Second Amendment. And it even uses the word reasonable. So the Second Amendment, the Supreme Court is on record on this one, that reasonable gun control does not violate the Second Amendment. Lower courts have sort of been fumbling through to find something like a standard of review or a test that they can apply in Second Amendment cases. We've all referred to this. The standard they seem to be sort of coalescing around is sort of a two-step approach. The first step in that approach asks whether the activity that's at issue actually falls within the Second Amendment at all. This is kind of like a threshold question. And there are certain gun-related activities which don't. Courts have generally found that concealed carrying, for example, because it was historically prohibited in most places. In fact, the South led the way on prohibiting concealed carry. Interesting historical nugget for people who believe that to be sort of the heart of gun culture. Those kind of things aren't even protected by the Second Amendment. Those cases end there. Even for things that do trigger Second Amendment scrutiny, courts have not said, okay, just because this law burdens protected activity, it's unconstitutional. Instead, they've asked, is the burden on protected activity here justified in light of the government interests at issue? And so laws like licensing laws, for example, which require you to show good cause or special need before you get a permit to carry a gun in public, those have generally been upheld. As I mentioned earlier, laws forbidding possession by people under protective orders, et cetera. Lots of laws, the vast majority, in fact, have been upheld. There are obviously some big exceptions, the D.C. Decision last week, which we'll see what happens with that one. Happy to talk about that more. Of course, the decisions in Heller and McDonald alone affect millions of people in cities which suffer hundreds of gun deaths. So these are very important. But by and large, the Second Amendment, as a doctrinal matter, is not the cause for the perceived lack of gun control in this country. I would say that although the doctrine and the courts are not the ones that are keeping Second Amendment, keeping gun control off the books, the Second Amendment has this rhetorical power, which is maybe strengthened by Heller, and so that people who believe in or profess to believe in gun rights often present the choice. You can either have the Second Amendment where you can have gun control, you can have Heller, or you can have gun control. And Heller shows that's a false choice. I mean, Heller itself endorses as constitutional various kinds of gun control. You don't have to choose. But politically, that's extremely, extremely effective and powerful. Robert Rabin, in his introductory remarks, mentioned the proposal for universal background checks that failed to clear, despite, according to some polls, being supported by like 80 or 90% of Americans, including like 75% of gun owners, and I think a majority of NRA members. Right? This was as close as you can get to something that you just expect to go through, even given the dysfunction in the gun debate. And the reason must have something to do with the really strong opposition of that 10 or 20%. Well, when you look at the polls of those folks, why is it you oppose universal background checks? That's what we use to exclude felons, the mentally ill, et cetera, from getting guns. The most common reason given is the Second Amendment. And that's not a statement about doctrine, or at least not an accurate one. No court, I think, would strike down universal background checks, but it is representative of this sense that, rights are absolute. If you believe in a right, then you can't believe in regulations of that right. And so, I don't think you can measure the impact of Heller and the Second Amendment generally just by counting up the number of laws that have been struck down. You have to look at the laws that never got on the books in the first place, and that's where I think if there's a misunderstanding about Heller, I think it's missing where it's really having an impact.
Mr. Waldman, I mean, your book talks about this quite extensively and quite persuasively about how the Second Amendment gained that kind of rhetorical appeal. How did sort of political mobilization sort of change the meaning of the Second Amendment?
Well, it really is a classic American story of how constitutional change really happens. It actually is the role of the NRA and other gun rights advocates over 3 decades' time to change the way the country saw the meaning of the Constitution, in this instance of the Second Amendment. And we all have much to learn from how that happened. The NRA, as we know, is a long-standing organization. It was founded after the Civil War by Union officers concerned about poor marksmanship by the troops. It focused on training, on sportsmanship, on military preparedness, and eventually as a voice for hunters and sportsmen and those old American Rifleman magazines that Professor Winkler mentioned more often than not had somebody holding up a mountain lion on the cover. What changed? Well, in some respects, what changed was the 1960s. The social transformation of that period yielded a backlash in the 1970s across a wide swath of American life, and that backlash is what we have been living with and living in for the next 30 years. In 1977, the NRA, up until that point, they were never wild about gun laws, but they testified in support of the first federal gun law in the 30s and were asked by Congress, does this seem to fall foul of any constitutional provision you can think of? And they said, we haven't given that any thought. They were supportive of some of the gun laws of the 1960s. In 1977, it was made clear that the NRA intended to move its headquarters out of Washington, D.C. to Colorado to underscore its retreat from politics, if you can believe that. At their annual meeting in Cincinnati, it's known as the Revolt at Cincinnati, 1,000 activists came, voted out the old leadership, voted in new leadership that was far more dogmatic, far more political, far more doctrinal, and focused on remaking the organization as a constitutional crusade around the Second Amendment, and using that both as a rhetorical argument but also as an actual legal and public argument. And the campaign was the same kind of campaign for constitutional change we see in a whole host of other contexts in American history. They actually started with scholarship, backing quite a bit of scholarship. They and other gun rights advocates backing quite a bit of scholarship to show what the real original intent was, that there was a belief in the founding era in an individual right and so on. Some of it is very good, some of it I would argue, and I argued in the book, is quite flimsy, but it was very influential. They moved public opinion so that over time, the view of the public of what the Second Amendment meant shifted, so that it is really now a common sense and consensus and widespread view. Well, of course, it refers to an individual right. They, of course, as we know, elected politicians and defeated politicians, but they also moved to change the positions of the organs of government so that, for example, the Justice Department switched its position of many decades about what the Second Amendment meant. And then and only then did they go to court. Only after winning in the court of public opinion did the NRA and gun rights community try to win in the court of law, so that when that case eventually went up to the Supreme Court, it pretty much fell like a ripe apple from the tree. It wasn't ultimately all that controversial. And that, of course, is how constitutional change happens in the United States. It's almost never a pristine understanding of a constitutional text. It's always the push and pull of advocacy and organizing and public debate. That's how we got civil rights. That's how marriage equality is sweeping across the country in addition to the skilled advocacy in the courts. That's how the voting rights fights are being won by pro-voting rights forces these days in the courts. It is how we are going to have to wage a many-year drive to reverse Citizens United, and I would argue Buckley versus Vallejo and a number of the other misguided Supreme Court cases on money and politics. That's how we do constitutional change. And it is really interesting that the reaction to this idea that the NRA waged a campaign successfully to change the way we see the Second Amendment, their response to that lately has been to deny that it happened, to say, no, that's not really what happened. This has always been the understanding. The Miller case was entirely consistent with the Heller case, and everyone's always known all along what it meant. You know, in a way, I think they're being unduly modest. But whether you agree or disagree with the outcome, it's the classic way constitutional change happens in the United States, and progressives generally and people on the gun issue in particular have much to learn from it.
Well, and I'm going to put Professor Killen back on the spot a little bit here, just in terms of, from a historian's perspective. Is that a possible way for gun control advocates to think about changing the understanding of the Second Amendment through that kind of political mobilization, popular support, public rhetoric? It was successful for gun rights groups. Is that the way that maybe gun control advocates should think about approaching Second Amendment questions now?
Yeah, The interesting thing about, if you go back and look at Heller and McDonald, is that the rhetoric about all of the children that die because of guns in homes, the rhetoric about all of the harms is confined to the dissenting opinion. It's absent from the majority. And quite frankly, from my brief exposure to the American Rifleman, there was a column in it every month that gave anecdotes that were powerful, powerful anecdotes about gun accidents that could be used from the official house organ of the National Rifle Association as part of this process of developing intense public awareness of the problems caused by unregulated gun possession. And the NRA has done a very, very good job of convincing people that if guns are outlawed, only outlaws will have guns, and that any regulation of a gun is the first step in the confiscation of them. And I think if those who are deeply concerned about this could shift that rhetorical trope, get people to understand that responsible possession, responsible ownership, educated ownership, and responsible regulation can lead to significant public safety developments, you can start to shift the dialogue. So, for example, the trigger lock, which was part of the Heller stuff that was taught. What about a measure that says trigger lock if there's children in the home? Predicated on all of the accidents where children go into the closet, go up on the shelf, get the parent's gun, and kill their sibling. These kinds of things can become part of that process that plays into what he has talked about in terms of shifting the dialogue. And it's what the NAACP did in terms of the long-term strategy they used to bring Brown to the table. There's 60 years of litigation and public dialogue that lead to that, and even then, another 20 to 30 years before we get effective court decisions that are going to do something other than all deliberate speed. And you've just got to recognize that it takes time and it takes effort.
And Professor Blocker, let me ask you one final question before we'll open it up to the audience for questions from them, which is, I think, an important question for gun control advocates today, which is, should Heller be overturned? I mean, should the goal of gun control advocates be to overturn Heller in the way that the goal of anti-choice advocates was to overturn Roe versus Wade? Is that where gun control advocates should focus their energies on sort of this long-term, let's put the seeds in place that will grow and eventually lead to the overturning of the Heller case?
It's a good question. I think that those seeds are going to have to go through a lot of growth before that happens and before it becomes really like relevant in terms of what the landscape of gun control would look like. I don't see the court revisiting and overturning Heller anytime soon, short of some major personnel changes. I think it's here. I think we have to and can learn to live with it. As I said, I think it preserves enough regulatory space that we can probably fill. The fact is that even if Heller were gone, and Michael Waldman alluded to this in his comments, 75% of Americans think it was rightly decided. And so, as I was saying earlier, I think that the primary obstacles here, at least right now, are political rather than constitutional. I don't think Heller is the reason, outside of some very important but limited number of cases, that we don't have any more gun control. So I think the trick is to figure out, okay, look, given this holding that we've got and given the regulatory space that we have, how can we find some kind of accommodation which might permit gun control or the kinds of gun control that may save lives? The afternoon panel certainly will talk more about that, and I think there are some options. I mean, one option or one possibility, which I floated before, which I think jibes well with hopefully what the afternoon panels will say, is to consider the fact that gun control and gun rights mean very different things in different parts of the country, and we don't necessarily need to have the same rules and even the same constitutional application of those rules in different places. We have one Second Amendment. There's one holding of Heller. It applies everywhere in this country. The holding of Heller is a national holding, but to say that is not to say that it necessarily cashes out the same way in every single place. I mean, you can have a rule that says, for example, and I think this is kind of what Heller is fumbling towards, that gun control laws which are long-standing and traditional are constitutional or presumptively constitutional. Now, that's a single rule that applies everywhere, but if you look at what the traditions are in various places, you get different answers. And this is back to Michael Waldman's point. It is a tradition as old as the Second Amendment that guns are regulated more stringently in cities than in rural areas. That was true for Philadelphia, Boston, and New York at the time of the framing. It continued out to Tombstone and Dodge City out west. It remains true now, at least where cities are given the power by states to regulate. So if you have a tradition-based test, that's a single test, but it's going to get you different answers in different places. Or if you do what Justice Breyer suggested in his Heller dissent, and which seems to have influenced a lot of the Court of Appeals, and you ask to focus more on what he calls the details, what are the government interests involved with particular gun laws, that's also a single test. Gun laws are constitutional where the government interests justify the imposition on the right. That's one test. It applies all over the country, but it gets different answers in different places because urban areas, frankly, are racked with gun violence and gun deaths at a rate that rural areas are not. If you take the center cities of the 50 biggest metro areas in the country, that represents about 15% of the population, about 40% of gun-related deaths, right? This is a disproportionately urban issue. If you're doing the balancing, the interest balancing approach, you're going to get different answers in urban and rural areas. So that's taking Heller as a given, but trying to work out some answers that hopefully will sort of satisfy or at least accommodate various worldviews.
Terrific. I'd love to open up the floor for questions from the audience, if there are questions. Yes.
I'm sorry. Thank you very much. Just had a question, I think sort of at the intersection of sort of popular constitutionalism as well as maybe the elite advocacy at some point. Also, I think sort of relates back to Judge Scullin's decision here in DC last week. If any of you think an academic treatment of what infringed meant as an original matter, maybe through the 14th Amendment years, is there any value in trying to figure that out eventually to get to your point, Professor Blocker, get the court to some workable standard of review? I think Judge Scullin was the first that I've seen recently. I haven't read a lot of the recent opinions to actually say something like, I'm trying to figure out what infringed means. I think that if gun control advocates are going to get to a reasonableness standard of review, trying to articulate that as a matter, not just lawyering in court, but being able to talk to the person on the street who probably takes in a real sense, the view that infringed means encroachment of any kind rather than some sort of burden until the point of breaking. I've just been wondering that as I've been listening to all four of you. Thanks.
Anyone more?
Scullin, in his opinion, he talks about the complete and total nature of the DC ban that was at issue in the case decided last week. And it may well be that that infringed will come to turn on, is it a total ban in all circumstances versus a careful regulation that accommodates a variety of circumstances, so that if it's concealed carry outside the home, does anybody get to do it who can pass some minimal licensing, versus do we have some sort of a standard that says in this city for this type of weapon, this type of regulation is or is not appropriate. And I think, as I mentioned in an aside here, we have to understand that not all guns are the same. There's a wide variety of weapons. If you're carrying a revolver as opposed to a 30-shot magazine that discharges, my gun knowledge is completely and totally at a distance. I've never handled one or fired one, with the exception of the rifle my father brought back from Japan in World War II, and it couldn't fire. But there's a variety of guns, and there can be a variety of regulations, and it's the prophylactic regulations that have caused the most difficulty. And I think that comes to what you mean in terms of the question about infringed. Total ban, careful regulation.
Where the recent DC case falls is, of course, on the question of carrying weapons, and this is where there's been some of the most interesting jurisprudence in the various federal circuits. Taking a large step back, since Heller, the federal courts have overwhelmingly upheld gun laws when they've been challenged. Robin Peters' group has calculated, I believe, 96% of the time those gun laws have been upheld, because the courts have said, yes, there's an individual right, some enthusiastically, some grudgingly, but society also has a right to protect itself. Government has a compelling or powerful interest in these laws. The people have expected for a while that perhaps the Supreme Court would step in again to articulate where and how far that right extends to carrying weapons outside the home, but it has chosen not to do so. Most recently in the Third Circuit, where the Third Circuit upheld a very strict law, and it has so far, when you look at the various circuits, it has turned on whether there's a full prohibition or, short of that, a very, 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 very strict law, which have been upheld. Even in the Seventh Circuit, where ironically Judge Posner is one of the most compelling articulators of the view that he's a critic of the Heller case, and of course a leading conservative legal intellectual, and argues, among other things, on the localism basis that cities and rural areas really are different, and that cities ought to be able to experiment with laws to deal with their particular challenges. Nonetheless, he struck down Illinois' ban on carrying weapons, but pointed to the Second Circuit case, Kachowski, which upheld a longstanding law, which was and is very, very strict. So it may be that what appears to be division among the circuits actually is much more agreement, but it depends on what the underlying law is. Interestingly, the District of Columbia offers some opportunities, because in Illinois, the gun lobby was very powerful in the state legislature in drafting the new law to replace the old law. Here, there's actually the opportunity to put some real thought into what a modern and appropriate law to replace, if this current court decision stands, which I'm not sure it's going to, and certainly don't necessarily think it should. But if it does, the city council here has the ability to take another stab at it and actually craft a modern version of what could be appropriate under the Constitution.
Let me just add 3 quick points responding to each of the 3 comments there. I think your point about what did infringed mean at the time, that would be a fascinating scholarly enterprise, and I think the way you'd sort of flesh that out is through what was mentioned earlier about the sort of Madisonian notion of liquidating meaning, sort of in practice. And I think you would look, okay, look, what did it mean to them? Well, they passed these really stringent gun laws. They must have thought that it does not infringe the right to keep and bear arms to ban the storage of gunpowder in one's home or loaded weapons or something. And you might be able to get some traction there. So I would imagine there's some very interesting historical work to do there. On Judge Scullin's opinion, I don't want to echo too much, but just to emphasize what Michael Waldman said, I think is exactly right. To say that a flat ban on public carrying is unconstitutional is not to say that even a stringent licensing requirement for public carrying would be unconstitutional. In fact, most courts, Kachowski's one, Fourth Circuit as well, have upheld laws that say, okay, look, if you're going to carry a gun in public, open or concealed, you've got to show good cause, you've got to show special need. New York has a law, it's the Kachowski case, it's very stringent. California has one as well, or counties in California have them, or cities do. So those kinds of laws, even if this opinion stands, DC can rewrite the law and say, okay, look, you can have it if you can show us that you have a particular need to exercise self-defense. And third, going back to Professor Killenbeck's point about certain guns are different. I think this is one of the hard things for liquidating what the meaning of arms is, right? What kind of guns are covered by the Second Amendment, as well as what the word infringed means. And as I mentioned, the court in Heller says dangerous and unusual weapons can be banned. It does not tell us what counts as a dangerous and unusual weapon or how to figure that out. And I think that's another place where the urban-rural divide actually can be useful, because there are certain kinds of guns, high-powered rifles, 50 caliber rifles, for example, might be less dangerous and unusual in a rural area where you're hunting things that are very far away, but in a crowded urban area present particular dangers. And so I think just like First Amendment doctrine in some ways has some kind of local tailoring, obscenity doctrine imports community standards as part of its test, I think you could do the same thing in terms of defining what kinds of weapons count as dangerous and unusual. DC is going to have different answers than rural North Carolina.
Very quickly, when I wrote the book a year ago, I said rather flippantly, well, looking at the work of Nelson Lund is one of the pro-gun rights writers who I think is most thoughtful, and he makes the point about, we have to admit the guns now are different and they're more powerful weapons now than there were then. And I wrote, well, are we, one has to ask, are people, these days one would say that an individual should be able to have drones, and that at the time seemed like a very fanciful notion. This was before Jeff Bezos went on 60 Minutes and announced Amazon's drone program, and before the Supreme Court granted constitutional right of conscience to corporations. So the question may someday be, does Amazon have a constitutional right to arm drones under the Second Amendment? We may find out.
I think I saw that movie. Wait a second. Dystopian future. And worth noting with regards to the D.C. case that was decided just recently, striking down D.C.'s complete ban on carry, I would have thought that case was in big trouble going up to the Supreme Court if you had asked me a year or so ago. Now I'm not really quite so sure. One thing that's happened in the Supreme Court, that despite the sort of boldness of the Heller and McDonald decisions, the court since McDonald 2010 has really shied away from taking another gun case. The biggest unanswered question after Heller and McDonald is, does the right to bear arms protect a right to carry guns in public? And if so, what kind of permitting regimes can states and local governments have? Every state in the union now allows people to carry guns in public if they have a permit. And there's variation in these permitting regimes. Some are very restrictive and some are very permissive. The Supreme Court has had the opportunity to take a carry case now several times over the last 2 years. They had several good cases presented to them this year that were petitioned for certiorari, brought by good advocates, good plaintiffs from the pro-gun perspective, and yet the court didn't take any of these cases, despite the fact that the justices are not only plainly aware that there's a lot of dispute in the lower courts about the question of permitting, about the nature of the scope of permissible gun control laws under the Second Amendment. They even had a brief filed to them in one of these cases this year by Paul Clement, arguing that the lower courts were engaged in massive resistance to the Heller and McDonald decision, sort of invoking the civil rights cases that Professor Killenbeck mentions on all deliberate speed and whatnot, trying to sort of goad the court to really step back in and forcefully protect the Heller and McDonald decisions. And the court didn't take that case. And no one knows exactly why, but it may be that the justices are not as clear on whether there's 5 votes for public carry and under what circumstances that might occur. Question?
Yeah, you had some great discussion here about how the Heller decision has emboldened basically political activists on the pro-gun side to challenge existing laws and advocate for looser gun laws. I'd be very interested in hearing what you think about how the Heller decision and the McDonald decisions have emboldened insurrectionists, people along the lines of Cliven Bundy and his followers, or the 2 individuals who spent time in his camp and then murdered 2 police officers in Las Vegas. How do you think these decisions have emboldened individuals like that? And then what, in your mind, would be the counter argument against that to kind of flip that debate specifically?
To the degree that I don't know that I think that Heller and McDonald have emboldened, broadly speaking, Second Amendment fundamentalism as a rhetorical matter, because when the Supreme Court speaks, even though it was a limited doctrine, one in which strong gun laws can emphatically be upheld, it takes on a kind of an intellectual and public life of its own. It is striking how much the arguments of many, not all, gun rights advocates have turned away from protecting hunting and other things that even 20 years ago were what people worried about and talked about, toward this insurrectionist line of argument. That didn't start with Heller, of course. In the 1990s, when I was working with President Clinton, we had the militia movement then, and there was quite a close connection between the language used then and what gave us the Oklahoma City bombing. It is noteworthy to the degree that there is kind of an argument now made heavily, as we see in the Tea Party movement, of relying on the kind of the themes and emotions and thinking of the founding era as the basis for current arguments and thought. If you actually do look at what the framers thought they were doing with the Second Amendment, remember that the Constitutional Convention, the reason George Washington attended it was because of his fear of insurrection, of Shays' Rebellion, which had occurred right before the Constitutional Convention and was in fact the kind of sort of Clive and Bundy style, I get to decide what law I want to follow, armed insurrection, that many people now would say is the heart of the Constitution and the Second Amendment. And in the first few years after the ratification of the Second Amendment, George Washington and the framers again made pretty clear what they meant when there was another such insurrection, the Whiskey Rebellion, and the well-regulated militia marched out with George Washington at its head. The only time in American history a president has led forces into battle to crush the Whiskey Rebellion. So a lot of these arguments about insurrection are really kind of, I would suggest, fallacious as a historical matter. There was a debate then about what it meant, but it got clarified pretty quickly that a government and a country had to be able to maintain order, and it wasn't up to every individual waving their own weapon to make that decision. That's not a modern concept.
And it's odd to even think about the Second Amendment in insurrectionist terms if you think of it in the Constitution. Heller says that the militia clause is consistent with the individual right to bear arms because who were the militia? The militia were we the people. And so a well-regulated body of citizenry should have access to guns so that there wasn't a conflict between the idea of an individual right that belonged to the people and the militia, because the militia was a citizens' militia made up of able-bodied people who were required to participate in that militia. If that's the case, then remember what I said early on in the introduction, Congress has the power to organize, arm, and discipline the militia. And so if some insurrectionist group claims to be a Second Amendment militia, it means they're subject to direct regulation by Congress to organize, arm, and discipline them. So they don't exist outside of law. The idea that the Second Amendment would protect a right to destroy the Constitution that it was designed to shore up is kind of an odd idea and takes the Second Amendment not only out of the context of the militia clause of the Second Amendment, but out of the context of the whole Constitution, including the militia clauses of Article 1. I think we have time for one more question, if there is another question from the crowd. Okay, well, terrific. This has been a great first panel. Thank you all for coming. Thank you to my co-panelists. Thank you.